Hello, everyone. Thank you so much for joining us. We are excited to have you with us today and to talk about this really important topic and the changes that are going to be needed because of it. So we're talking about the Supreme Court decision that impacts buy-sell agreements. We're going to do a little bit of housekeeping and a few introductions here, and then we'll jump into the reason that you're really all here. So this is a webinar. To be clear about that, we cannot see or hear you. So if you got something going on right now or you're eating lunch, no big deal. But we do want to make sure that you're able to ask questions. So you should have two options for doing that. The chat feature should be available so that you can send both Ryan and myself a message and ask a question. And we will be monitoring that throughout the session. The Q&A feature should also be available. You'll likely find those down at the bottom of your screen, whether on mobile or at a computer. So again, we cannot see or hear you, but we do want you to send over all of the questions. That's really the main reason that we are here today. We do have one of our senior attorneys here with us, Ryan Raup. Ryan is going to be handling the legal side of this. I know you all don't want to hear that side from me. Ryan, would you give just a brief intro on yourself?
Absolutely. So I've been practicing at Evans and Davis for about 6 years now. I've been in the estate planning world for nearly 10 years. I was an intern in undergrad and then through law school as well, but been at Evans and Davis for about 6 years. And just like everyone else here, my focus is on estate planning and business succession planning. And so I've had a number of advisors and some clients reach out to us about this, and I'm excited to share the information with you all.
Yeah, Ryan's been doing a ton of work on this. Obviously, as you all know, things change and we all have to adapt to what the new rules and the new lay of the land is. And so Ryan's going to give us that whole breakdown. For those of you that I've not met, my name is Shelby Hayes. I'm the Chief Operating Officer and Marketing Director at Evans and Davis. And I'm going to give a brief background on Evans and Davis in case you're not familiar with us. Our entire firm all focus on estate and business planning. So all of our attorneys do this all day, every day with our clients. Really gives us that ability to stay focused and to make sure we're staying on top of changes, just like this one. We are really across the country as well. So all of us doing estate and business planning, and we're doing that in the majority of the states in the United States, and we'll here very soon be doing that in all 50 states. So again, really trying to stay in our lane to be able to give you and to be able to give your clients that really security and knowing that if something changes, we're going to be there and we're going to be on top of it. And that's what today is all about. We're going to get over to Ryan and jump into this. I did want to make note that we are recording this. So if you have to hop off or if you find this helpful and you want to share it with friends or family or clients, you're welcome to do that. A recording will be sent out as soon as this is over. Ryan, let's jump into it.
Thanks, Shelby. And again, thank you everyone for attending today. And for those of you who are not attending and going to watch later on, thanks for watching. I think there's a good amount of material here, and there's definitely some changes that we need to be aware of as one, practitioners, and two, advisors for our clients. So kind of the rundown from today, we'll go through kind of a broad overview of traditional buy-sell structures. Most of us may be familiar with the traditional routes, but it never hurts to have a refresher on that. Next, we'll jump to the Connelly case. That's the Supreme Court decision that I'll be referring to throughout the webinar as Connelly. It doesn't necessarily make headlines like a lot of the Supreme Court cases do. It's not really a political hot topic, but it certainly affects our clients in our world, and we need to be aware of it. And then we'll jump to best practices moving forward and how we can plan around the new laws and the Connelly decision, including with some life insurance LLCs. I'll touch briefly on that. And then determining whether if you're a client or if you're an advisor, if your clients should review their current and existing buy-sell agreement. So with that, traditionally, buy-sell agreements are structured one of two ways, and sometimes there's kind of a hybrid as well. So cross-purchase and a redemption agreement are the traditional routes that we would plan for. The cross-purchase is usually with two individual owners. It's the more simplistic route because Generally, buy-sell agreements are either funded with life insurance or they're going to be funded on the back end with some kind of promissory note. As a refresher, a cross purchase, one shareholder owns life insurance on the other and vice versa. When one of them passes, they swap the life insurance death benefit for those shares and then kind of cut ties. Importantly there, the surviving shareholder receives a step up in basis for the deceased shareholder's shares. So that's a good tax consideration that we take into account when we're determining the best route to go. Redemption agreements, and this is the type of agreement that the Connelly case rests on. The company purchases the life insurance or is the funding mechanism, and it redeems the shares from the deceased shareholder or the exiting shareholder. And so rather than the surviving shareholders individually owning the stock, the company buys it back from the deceased shareholder's estate and then generally retires those shares, leaving the remaining shareholders as the sole two or however many shareholders there are. This is really the type of agreement the Connelly case rests on. So again, kind of went through the buyout structures here and how to consider those. There's a couple of tax implications that I talked about. With a redemption agreement, you're not going to get that step up in basis. The company doesn't receive that either. Really, it rests on the number of owners. And so we'll have to do a little bit of a workaround, and there's some different considerations moving forward rather than just saying, well, it's 3 or more owners. Now it's a redemption agreement, 2 or less. It's a cross purchase. There's a couple of different considerations we have to take into account. And then obviously the finances of the company, what's the cash flow? What could a promissory note be appropriate from a cash flow perspective for the company? Those are all considerations we talk about with clients and with advisors when we're structuring a buy-sell agreement. The case was decided in June, so it's relatively fresh and it's new law. The law had been established for about 20 years, and that's kind of what we've gone on for buy-sell agreements for that time period. And so this really changes a couple of items that when we're talking with clients. So kind of some facts of the case here. It was 2 brothers that owned a business. One of them passed, the majority owner passed, he owned 75%, the surviving brother owned 25%. The buy-sell agreement was kind of a hybrid. It was structured as an option to purchase, as a cross purchase, or a required redemption by the company. The surviving brother chose not to do a cross purchase because they had company-owned life insurance that would be appropriate for that redemption traditionally. The valuation within the agreement was an agreed to valuation, or if they didn't do the agreed to valuation via cross purchase, there would be 2 appraisals. So the company redeemed the shares, and then lo and behold, the IRS steps in because the deceased gentleman did have a taxable estate, it turned out, and audited the deceased shareholder's estate and said that the influx of the cash benefit from the life insurance proceeds that was paid to the company increased the company's value. So that's pretty significant when we're thinking about valuating a company and how to structure the life insurance. Because you might be thinking, well, if they had an influx of cash to the company, that's an asset on the books, but isn't there a liability as well when we're having to pay out that $3 million death benefit? The court said because there's an exchange of shares for the death benefit, that it didn't create a liability, it just increased the value of the company. And that's really important to know, because if the value of the company is increased, and let's say we have a $3 million company with 3 shareholders, each one of them has $1 million of life insurance on them. One shareholder passes, an influx of $1 million is then given to the company. Well, now the company is valued at $4 million, and we only have $1 million to give out to the deceased shareholder. So we're still left with a gap there in that redemption agreement. So it's pretty powerful, and it's something that we'll have to work through moving forward. This is especially important with clients who have an estate tax issue. In this case, the revaluation of the company actually pushed him into having a taxable estate. And so his family had to pay estate taxes of around $900,000 because of the revaluation of the company. Granted, he was a majority shareholder, and the company was it was around a with the life insurance, it was around a $6 to $7 million company. But that's something that we all need to be aware of when we're looking at the bigger picture of not just the buy sell agreement in the company, but what does the client's overall net worth look like? I kind of just touched on this, but no matter what, if we have a redemption agreement, we're going to have a shortfall of cash because of the increased value of the company due to the influx of that cash. So there's a couple of workarounds I'll get to momentarily. Shelby, my computer's freezing up on me. Moving forward, redemption agreements should likely be reconsidered in most cases. I don't want to say that they are dead completely because it's completely client dependent. They just need to be aware of some of the shortfalls. Additionally, it could be really cumbersome to do cross purchases with a company that has 9 shareholders or 7 shareholders or a larger number of shareholders other than 3 or 4. If I was talking to a gentleman last week who said he knows of a company with 9 shareholders. Well, that would be if we did a cross purchase where each of the shareholders had life insurance on all other 8 shareholders, that'd be 72 life insurance policies. As a life insurance agent, that might be great to hear, but practically your clients probably aren't going to want to do that. And so kind of going back to what does the cash flow of the business look like? Can we maybe do some life insurance, but then fund the remaining portion of the buy-sell agreement with a promissory note or some other funding mechanism? If we have 3 or 4 shareholders, a cross purchase might be appropriate if everyone is insurable and maybe kind of on the same playing field from a health perspective in the underwriting. Again, that's something that the life insurance agents will have to walk through with the clients, but they definitely need to be aware that the cross purchase is going to be a more advantageous method moving forward from a tax perspective. A couple of ways to go to work around the Connelly case. The cross purchase structure, as I just mentioned, will have multiple life insurance on each shareholder. Sometimes they're not insurable. It depends on what kind of cash on hand other shareholders may have to pay out a deceased shareholder's estate. The redemption agreements, like I said, if they're a larger company with 9 shareholders, or even, if it's a company like the one I mentioned with worth $3 million and each shareholder has an equal share, it may be appropriate. And then that life insurance LLC, and I'll touch on the life insurance LLC a little more coming up. This is kind of specialized and it's really nuanced. It's not going to be appropriate in every case. We would form an LLC with the state that the company is registered in. And so this can be a redemption agreement because it's going to be taxed as a partnership. The only triggering event that's really applicable here, it would be death. Importantly, though, the transfer for value rule wouldn't apply because it would be a partnership. So if somebody exited and wanted to take their life insurance policy with them, we wouldn't run into any snags there. I know the transfer for value rule is a tax rule, and this is really where we would want the CPA to step in. And we would certainly involve them probably from the get-go when we're restructuring a buy-sell agreement that's already funded with life insurance, because we don't want to take out life insurance that's been purchased by the company and just switch the owner or switch the beneficiary. There's some real tax implications there that we need to be aware of, and that we really need an accountant or the company CPA to give us the authorization, or to keep those funded, do away with them, and then purchase personally owned life insurance, or set up this life insurance LLC that owns the life insurance policies, and it can be set up as a redemption tied to the actual operating business that we are utilizing the buy-sell agreement for. A lot of times these will have a third-party manager, which is just somebody who is kind of running the LLC. The partners would contribute the life insurance premiums for the other shareholders. So if me, Shelby, and another person had a life insurance LLC, I would contribute capital funds for the premiums on Shelby's policy, and as well as the other partners. That third-party manager would be the one kind of running the day-to-day, since there's not really any assets in the LLC. There's not a whole lot to do there, but it kind of removes the partners from any liability associated with that LLC, and it kind of separates that LLC from the operating LLC. Again, you'll need to consult with an attorney and the CPA before we set up a life insurance LLC that's specifically tied to the operating business that the buy-sell agreement really needs to be utilized for. When we're talking with either our partners or our clients to know if their buy-sell agreement needs to be reviewed, chances are if they have 3 or more partners, it probably needs to be reviewed. However, as you can see with the Connelly case, there was only 2 partners. And I've seen a lot of buy-sell agreements that will have that option for a cross purchase initially, and then a required redemption on the back end. In those cases, we probably still need to review those and review how the life insurance is structured as well, to avoid any pitfalls that we can come across. This doesn't necessarily apply for disability or divorce or any other triggering events other than death, because there isn't that cash influx of the life insurance from those other triggering events. This is really death specific, with the revaluation of the business. If they have 3 partners or more, then most likely they have a redemption agreement, and their buy-sell agreement for sure needs to be reviewed. If that's the case, get them in front of their attorney or in front of Evans and Davis, and we'll make recommendations, and we'll go from there. Ahead of that, if you're the life insurance agent on that has those policies that are tied to those agreements, be aware of which clients those are, and you might, as a good steward, ding them and say, hey, we set this agreement up this way. Some laws have changed, and no fault of anyone's. They likely haven't heard about it. I know I wouldn't have heard about this if this wasn't what I did every day. And so just as a good steward, kind of reach out to them. We've got a lot of clients in the last 20 years that we've done redemptions for, and we know we'll be able to satisfy their needs here. With that, kind of the takeaways, the main item here is that Connelly really changes moving forward how we do buy-sell agreements, and whether a redemption is appropriate. 9 times out of 10, it's probably not going to be, because a lot of the clients that I see and a lot of the businesses are 3 and 4 partner businesses rather than that 9 or 10 partner business. Cross purchases are really going to be the big ticket item moving forward. So as the attorney and as either an advisor or a life insurance agent, we need to be sure that structuring the life insurance policy and who the owners are, along with the payers and the beneficiaries, is proper moving forward. If it's a cross purchase, each of the partners should own each other's policies on each other. They should be the payors, and they should be each other's beneficiaries. Redemption agreements aren't completely nixed or out of the question, so I don't want you to take that from this. Like I said, in narrow circumstances, or if client is adamant about it, we can still do that. there's always the insurability concerns. And so if all three partners aren't insurable, then sure, we could probably do a redemption because um, there's no concern of that cash influx. Um, a note that's highly important is we should get our current buy-sell agreements reviewed before the estate laws changed in December of 2025. Um, as we all know, or as we may all know, the estate tax exemption levels are going to sunset at the end of 2025. And if we have any question on whether our clients are going to be at that 13 to $14 million range with everything included, we certainly need to probably do a more holistic review of everything, including the buy-sell agreement, the life insurance, and how everything's structured within that. So with that, we do have a good amount of time for some questions. If you aren't available to ask questions now and you're watching this at a later date, feel free to shoot me an email. My contact information has been on the emails, and I'll be happy to answer those.
All right, and love to see those questions coming in. Ryan, do you want to talk about the questions coming in over on the Q&A?
Sure. One of the questions is, what does the sunset law put the estate tax exclusion at in the rate? This is just our best guess. It's going to drop back down to 5 million adjusted for inflation. We all know what inflation's done the past several years. And so we're not 100% sure about that, but the general number that I'm going off of is 6.5 to 7 million per person. So for a married couple, 13 to 14 million. Does the death benefit proceeds from a non-partner key employee inflate the business value now? So that wouldn't necessarily be applicable for the buy-sell agreement. But if there's a cash influx, then you would presume that the value of the company would increase, especially there's no question there that there's no liability. So it's just receiving cash. Then yeah, I would say that it inflates the value of the business.
Ryan, one of the questions that we had come in over email was asking if this would have been different if they weren't brothers. So kind of talking about like, if my business partner is not a family member, does it change any of this for me?
It could change it, but the kind of the crux there is it still needs to be an arm's length transaction. So if we've got a $5 million company and we state the value in the agreement as $2 million, that's not going to be an arm's length transaction. That's one of the items the court actually noted in their opinion, was that these are brothers. This is a family this was a family corporation. It may not apply to all businesses across the board, but in all likelihood, from my view, I think it probably will.
I think getting a lot of questions too regarding whether is this only an issue for people who have estate tax issues, or is this an issue that all business owners with a buy-sell need to be paying attention to?
Yep, I've thought about that a lot. As an attorney, I can't say that it's not an issue for people who aren't going to be bumping up against that estate tax exemption. Either way, if the company is revalued by the IRS or if there's an audit, there could be some major problems there. If we've got a redemption and the company is revalued based on the influx of that life insurance, no matter what we did, we're not going to have enough life insurance to pay out for the redemption agreement. Again, going back to that $3 million company, if we've got $1 million on each owner and we've got the influx of $1 million, well, now the company's worth $4 million, and we're obligated to satisfy 1/3 of that to the deceased shareholder. So we're at a shortfall of about $300,000. So I can't say that it won't apply to people that don't have an estate tax issue, but it's a fantastic question. One of the questions are separate LLCs being set up to hold life insurance to fund a buy sell as a workaround to this. The answer is yes. That was that life insurance LLC that are quite nuanced, and that's relevant, and it's a workaround.
Ryan, an additional question on the insurance LLCs. So saying that 10 years from now, there is not a death, then and there's no like access here. This question's over in chat if you want to review the details so I don't mess this up too much. But so 10 years from now, there's no death, the insured would have the access to the cash of the policy. So what are we looking at for
Let
that?
me read that one real quick.
Yeah.
So the question for the viewers, if there is a company-owned life insurance for the purpose of a redemption, are you able to transfer those policies into a life insurance LLC without any penalty? With a life insurance LLC, is the company able to make capital contributions to the life insurance LLC for insurance premium payments? This is again a question more for a CPA, but if the operating company owns the policies now, and we simply move them to another LLC, you're probably going to have a transfer for value hiccup there. However, if we've got a new buy-sell agreement that needs to be a redemption, and we've got an LLC, a life insurance LLC that we're putting into place, those capital contributions to the life insurance LLC will be paying the premiums. And then if somebody wants to exit or leave, since it's going to be taxed as a partnership, there's no transfer for value hiccups there. They can just take their policy and they can exit. There's still going to be, terms in the buy-sell agreement for, well, what's the value of the business and how do we pay out an exiting shareholder? But the life insurance is not going to be relevant in those situations. What is the difference with the life insurance LLC and an ILET? ILETs are for personal planning. The life insurance LLCs are for the specific purposes of a buy-sell agreement. And so in some situations, it might be appropriate to incorporate an ILET into the life insurance LLC, but kind of segment those out between the personal and the business side of things. Who owns the cash value of the life insurance in the life insurance LLC? The life insurance LLC would own that cash value because they are the owner of those policies. But again, if we transfer those out, there's no transfer on value rule as a partnership. So this really accentuates the need for high net worth clients to have personally owned life insurance to cover estate taxes. Yeah, high net worth clients generally would have their life insurance probably not owned personally, but owned in a life insurance trust. But it definitely increases the need for taking a look at the holistic picture, like I said. Inside an insurance LLC, would the owners have access to the cash value? If they took those out, then yes, they would. But generally, the proceed the cash value is going to stay within the life insurance LLC.
I feel like this has been such a good rapid fire. You guys keep the questions
Absolutely.
coming. That's certainly why we're here, and hopefully we're being able to answer all of these questions as they're coming in. It seems like the Q&A section is working easier for us to just digest those questions as they're coming in. If you don't mind throwing your questions over in there, that seems to be working better.
That was definitely my goal. And nobody wants to hear an attorney talk to them and lecture them for 45 minutes or an hour. So I love the question and answer format. It's much preferable to me. Full transparency, I can't answer this one with 100% certainty. So Joe, well, the question about a reverse split dollar policy for funding the buy-sell agreement, if you'll email me, I'll get back to you with an answer on that.
Ryan, I had another question over on email that says if the properties for the business are held in LLC, does that impact the business's value?
If the property for the business are held in in a separate LLC.
I think that's what we're talking about here. I didn't have any more details on it.
Um, it would really be agreement specific. So sometimes if there is an operating LLC and a property LLC, those I've seen buy sell agreements where they're lumped into one. And so it would kind of be viewed as one bucket for evaluation. But if there's two separate buy sell agreements, and generally with real property, clients are okay with their family inheriting their share or being in business with another partner because it's just real estate. There's not a whole lot of action that goes on with it. But if there is a buy-sell agreement for the real estate and the operating business, those are two separate entities and two separate buy-sell agreements.
Sorry for our delay here, just reading those questions as they're coming in.
Well, sorry, Shelby. I'm
You're
having a
fine.
hard time seeing the actual chat.
You've got another one over in Q&A too, if you want to check that out, and I will get chat pulled up for you.
You mentioned insurance LLCs. What are your thoughts on the use of cross-endorsed buy-sells as an option? Again, if you'll shoot me an email, I can't give you a 100% clear picture on that, and I don't want to say something that's out of line or give you an answer that I'm not fully confident on. So shoot me an email, and I'll get back to you on that one.
Give people just a couple more minutes here to throw in your questions. And while you're adding those in, just a couple of notes from us. We are working on a lot of additional communication, not just the webinar. We will send the webinar recording so you all can utilize this if you would like to share it with teammates or share it with clients. But we're also working on some more marketing materials and blogs and things like that that will be available for you very soon too.
Another question, if we have a single owner, 100% ownership, should we have their trust own the life policy? I mean, generally, it depends on what the life insurance is going to be used for. Generally, the trust is going to own the business anyways and determine where it goes and who it goes to. And so with those, you're looking at an influx of cash to help the business keep running until we can sell it or until it's distributed. Depending on the value of their estate, I would say maybe, yeah, their trust should own it, but it depends on the purpose of the life insurance realistically and what the value of the client's overall estate is.
Okay, those questions are starting to die down. Ryan, why don't we go back to our takeaways and just hit those high points that we really felt like are the ones that we think are important to remember on this topic, and
Sure.
then we'll see if any additional questions come in during that time, and if not, we will thank you all for coming and move along.
Yep. Again, going back to the takeaways, I don't want anyone to think that redemptions are full stop non-existent anymore. So that's not necessarily a takeaway, but I think we're going to go from the traditional route of thinking of three partners redemption agreement to let's consider if we can do a cross purchase here and if this makes sense and if they can afford the life insurance premiums rather than going with that redemption route, especially for the higher net worth or the higher valued businesses. And then, of course, reviewing current buy-sell agreements and being aware of this when you're talking to future clients for future buy-sell agreements is definitely critical. Just my goal here was that everyone on the call is dangerous enough to know about this. Certainly, the attorneys that you're working with will be the ones to get into kind of the nuts and bolts and work alongside your CPA. And then we will rely on the life insurance folks or the advisors to structure the life insurance appropriately based on the client's preferences and our recommendations after going through the consultations. With that, I know I've asked a couple of you guys to email me. My email address is up on the screen. It's just ryan@evansdavis.com. I will take a look at them, at your questions, and try to give you as detailed of an answer as I can. If I don't fully answer your question, or if you're unsatisfied with the answer, please let me know. I'm human too, and I want you guys to get the most and the best information possible. So feel free to reach out to me anytime.
And also too, if you're not already working with Ryan, you're working with another one of our attorneys, they're all up to speed on this topic and are happy to answer your questions about it. And obviously, if they're more familiar with what your specific situation is, it may make more sense to go directly to them so they can answer in even more detail. But we're all here to help. We're excited to work with you on these projects. And just as you have questions, feel free to send them over so that we're able to get those answered for you. Ryan, any last words?
I think that's it from my end. Again, happy to answer any questions anyone has, and thank you guys again for attending. It's much appreciated.
Have a wonderful day. Thank you so much.